Good morning. Everyone's so quiet. I hope everyone had a great weekend. Today's Monday, February 26th. Welcome to the First District Court of Appeals. We have 4 cases on the docket this morning. 2 of these cases we'll be arguing today. The first case that we have is case C230295, State of Ohio versus Jeremy Hardman, and that case has submitted on the briefs. The next case that we have is, you know what, I don't know if this is the right docket.
We're here on Hardman.
Yes, we're going to get the right docket. Thank you. Okay. Okay, so that case is scheduled for argument. All right. Then we have cases number C220426, 427. Okay, there's just a little typo there, but, okay, which is Joan Jones Durrani versus Durrani and Dana Conley versus Durrani. The next case we have is C230180, and that case is also scheduled for argument. And I'm assuming counsel is here ready to proceed on that. Yes?
Your Honor, Philip Williamson here on behalf of Dr. Ramani, the Jones and Conley case.
Yes.
The others are not.
No, not for Hardman, I understand. So we have Philip Williamson, who's arguing on behalf of Durrani, and Alan Statman. Attorney Statman, yes, okay, thank you. Then we have cases number C230180, 181, and Alexander Anderson versus Durrani. We also have Attorney Statman on that, and Attorney Whittingham. Thank you. And the last case we have is case number C230182, 183, which is Katrina Branton versus Durrani. And I understand that that has submitted, and you'll only be arguing on the Anderson case. Okay, very good. Now that we've got that all squared away, we'll start off with State of Ohio versus Jeremy Hardman. Good morning, Attorney Allen. How are you doing?
Good. Good morning. I'm doing well.
Would you like to reserve time?
3 minutes, please.
All right, you can start whenever you're ready.
Thank you. May it please the court, Mr. Cummings. I think the court is well aware of the history and the facts of this case. We've drug it back and forth a few times. So I'll just get right to the 2 arguments that we're here on this morning. The right to testify issue, I think it's somewhat interesting in terms of that this is as essential a right as the right not to testify. Usually what happens is there's a waiver and the judge will say, you know, you have a right to testify, you have a right to get up there and say what you're going to say. I think that is probably by local custom. The different courts I go to do it different ways, but I still think that it's, if it's a essential right, which I would argue that it is, that it's something that has to be waived, where you say, are you drunk, are you high, are you doing this voluntarily, are you doing this?
Now, Mr. Hardman was represented.
He was.
He not? So how does that change anything?
No.
And why is that?
Well, I think the record is bare as to the waiver. I think I've said this before, the judge, the common pleas judge, is required, he's the person that, he or she is the person that is the keeper of the rights, that protects the defendant against the government. So the judge should have had a colloquy with Mr. Hartman. The fact that he's represented and given his trial counsel's testimony at the evidentiary hearing, it was somewhat clear that the judge should have said, hey, do you understand that you can testify? If you're not going to, that's fine, but I don't think.
When would you say that that colloquy should have taken place?
Before the defense rested. I think generally, if you look at local customs, it's generally before.
So what kind of claim is that? I read your post-conviction petition to couch that as ineffective assistance, but what I'm hearing now is that you're really placing the responsibility on the shoulders of the trial court.
I would say it's probably both, as this person is not trained in the law, that this is an essential, important right, and that both his lawyer essentially made the decision for him, which he can't do. The case law is fairly clear that he cannot make that decision. If the defendant wants to get up there and make a fool of himself, the defendant has the right to do that.
How did the lawyer make the decision for him? My understanding is that he advised him not to testify because he didn't think he would make a very good witness, and he didn't think that he needed to testify because they got the jury instruction that they wanted, right?
Correct.
So how did the lawyer make the decision for him?
I believe if you look at the evidentiary hearing, Mr. Cohen questioned Mr. Bennett fairly extensively on the question of whether or not he would testify, and I believe that he said he told him not to testify. I believe that.
Isn't that a normal conversation that defense counsel has with their clients in a trial? That, hey, I don't advise you to testify, and
Yes.
it's not necessary.
Yes, but usually that's followed up with the judge inquiring of the defendant, because I think, again, the judge is, and I'll admit I didn't argue this in the brief, so this may be.
That goes back to Judge Kinsley's question. This is an ineffective assistance of counsel claim, so we have to focus on deficient performance here.
Yes, so I would say that not allowing his defendant to testify falls below the standard, and it goes, that's the second prong, I think.
And are you saying it falls below the standard as a general rule, or is it something about the nuances of this case that you're relying on?
I would say as a general rule, that taking it upon yourself to.
And is it a general rule for all criminal actions, or is it something about this particular case?
Well, I would say for all criminal actions. I don't think it's specific as to Jeremy Hardman or Clyde Bennett or the judge in this case.
No, I didn't mean that way. I mean, this
Right.
is a self-defense case, and there were state-of-mind issues.
Oh, I would say in terms of this case, there are some interesting specific questions that the jury would have had that only Mr. Hardman could have answered. I think that the prosecution will say, well, he followed them home. Well, in reality, Mr. Hardman testified or revered in his affidavits that he wasn't following them home, that he, turned around and then he came back. He would have testified that that's not what happened.
Is that the prejudice piece? And if so, what do we do with the trial court's finding as to lack of credibility?
Well, I think that you're always going to have to look at the trial court and look at the record, including the affidavits and including the trial testimony. I don't think you have to give it absolute deference. You have to give it some deference because he had all of this information in front of him. But I think that, he's as credible as the witnesses against him. So I think that,
Well, that's not exactly what the trial court found. I mean, the trial court made a specific finding. The credited defense counsel's testimony as credible and discredited Mr. Hardman's testimony as not credible. We're not seeing these witnesses. We're not able to make an independent assessment of that, so.
and of course, the trial court's in the best position to make those determinations. I would say, certainly if you're looking at credibility and what issues that you have to look at in credibility, the lawyer in an evidentiary hearing facing ineffective assistance in counsel claims has much more, probably as much to lose as the defendant sitting in prison for 26 years.
Why is that?
Well, I certainly think that there is, professional issues that could arise if he's found to be ineffective. There are financial, malpractice and ineffective have repeatedly said not to be the same thing, but certainly that can be something that can go into his credibility. Unfortunately, the record is not as, the evidentiary hearing was not as developed as I would like to be. That's, I'm stuck with that. There are certain things that it's always difficult for a court to say that a lawyer is lying, but I think if you are not being completely truthful, and it's much easier to say that the defendant is lying and not being completely truthful because they're a convicted defendant. So I think looking at all the facts and the record as it is, while giving some deference to the trial court, I think from what you have, I think you can make a determination that Mr. Hardman is credible.
Why isn't this a case where the defense attorney gave his best professional advice and simply guessed wrong?
Well, I think that still can be ineffective assistance of counsel.
In what way?
I think if you guess wrong and the guess is not based on investigation, if the guess is not based on research, if the guess is not based on things that come into your purview as you research and investigate the case, then I think, what was told to the defendant was that I'm going to win a trial, which that's almost, you can't make that promise. And, I think that goes into the second part, but I think when you are making a guess, it's not really what we do. If you do it long enough, there are certain things that you should know. I understand someone that has a license can try a capital case, well, not a capital case, but a murder case. But, keeping your defendant from testifying and, being just completely okay with just getting the jury instruction, I think is not, there was nothing. The other part to that is there was nothing for the jury. They got the jury instruction, but there was nothing for the jury to find him not guilty by self-defense or by find him guilty of manslaughter.
So you're basically saying that the deficient performance was relying on the jury instructions rather than bringing in evidence from
Yeah.
his client?
Yeah, well, I think they're both. I think the jury, you get the jury instruction, that's great, but in terms of them being able to find it, there are no facts in front of them to find that. So they put one person on that was really provided no factual predicate for the jury to find him either not guilty by self-defense or by manslaughter. There's no. So if he would have testified, I think all of these things, would he have been acquitted, I would say he has a much better chance.
Counsel, you have about a minute, okay?
Okay. If you have no further questions, I'll reserve the rest of the time.
Okay.
Thank you.
Thank you. Good morning, Attorney Cummings. How are you?
Very good, thank you. I would like to just give my opinion of reading this record. The evidentiary hearing, as short as it was, I think is very telling. What comes off from this hearing is that Mr. Bennett did an exceptional job in this case. And I think every decision he made is borne out by what transpired. And the problem, the inconvenience for Mr. Hartman is he first has to convince this court that Mr. Bennett was somehow ineffective. And it's clear from everything that is documented and testified to at that hearing that Mr. Bennett did an exceptional job for this man.
Well, at
His
that
reading
point,
of-
isn't it pivotal to that hearing, the credibility determination?
Oh, absolutely, yes. That's very important. And I think, as you pointed out, the judge did not think Mr. Hartman was exceedingly credible, but an interesting thing to note is that this is an evidentiary hearing, and this was his opportunity to tell the court and to tell this court and to tell everybody what this critical testimony is that he had in his back pocket, that if only he could have testified at trial, he could have made a difference. And they put no meat on the bone here, Your Honors. They did not advance this claim. This was his opportunity to tell everybody what his...
So he didn't talk about state of mind in that hearing?
He did not, he was asked a few questions by Mr. Cohen about, was this rebutted, or is this something you would have liked to speak to? And he said, yes, but there was no follow-up, and he didn't volunteer anything. So at the end of this hearing, we still don't know what he would have said at trial that would have made a difference. And that's what I find striking about this, because even if you want to indulge the hypothesis that Mr. Bennett was somehow ineffective, which I really don't think can be done on this record, you still have to show prejudice. And at this hearing, he showed nothing. We know nothing more now after that hearing than we did before. He still didn't explain why he hid. He didn't explain why he hid the truck. He didn't explain why he didn't call the police. He didn't explain why he didn't flee when he had the chance. I mean, if he was saying that this is my chance to talk, if I had just been given a chance, I could have made a difference here. This was his chance to do it here at this evidentiary hearing, and it didn't happen. But I don't think this court even has to get to the lack of prejudice. I think you just have to look at Mr. Bennett's performance here, and there's no way you can characterize his performance as anything less than exceptional. He read the trial judge correctly. He read his own client correctly. He predicted that this client was not going to do well in front of the jury. He was not going to be a good witness. We do see that borne out at this evidentiary hearing. I think Mr. Bennett did a fantastic job. Like was pointed out, he got the jury instructions on self-defense and the lesser included offenses without putting Mr. Hartman on the stand, and that is well done. I mean, that is just a very good thing to be able to do simply by cross-examining other witnesses.
Counsel, what was in the record to justify the trial court's issuance of these jury instructions?
The family of the victim, there were 4 or 5 family members that testified at the trial, and they all described the events that they observed. And much of what they described was how their brother, the victim, who was a very big man, 6'3", over 300 pounds, he was angry, he was agitated, he had to be restrained, he was charging at Mr. Hartman's truck. The evening was dark. They admitted that probably Hartman would not have been able to see his hands if he had had a weapon. So Mr. Bennett was able to elicit all of this testimony, which supported a self-defense concept from the victim's own family members, and he did it expertly. He's been commended by the Supreme Court for doing this before. He's able to do this without putting the defendant on the stand and subjecting them to cross-examination. Mr. Hartman got exceptional performance from Mr. Bennett. And unfortunately, in some of these cases, you don't get the results you want, but that's not ineffective assistance. That's just the way it goes in our jury system. And if the evidence isn't there, ultimately the jury is going to believe what they believe. But to say that Mr. Bennett did anything other than an exceptional job here, I just don't think is borne out by the record. If you want to entertain that, though, I still think Mr. Hartman has to show some prejudice here, and it's just not here. We don't know what he would have said that would have made a difference. And as far as taking the plea or not, I would draw this court's attention to his own affidavit. Mr. Hartman executed an affidavit on January 18th, 2017, paragraph 5, where he does say in the affidavit that I decided to decline the offer after consultation with Mr. Bennett. And I really think that's a moment of candor here, and I think that probably reflects what was going on. I think there was a very heated exchange, a back and forth. You probably know better than I do how that works with clients as you're dealing with them. But to think that any of this here demonstrates ineffective assistance by the defense counsel, I just think is just not supported by what this court has before it.
And one of your arguments in your brief with regard to prejudice on the issue of the plea was the outcome of the sentence in comparison to what was offered.
Well, he got more of a sentence than he would have gotten had he pleaded, you're right. And in that sense, whenever you have a claim like that, you're going to be able to demonstrate prejudice, I guess, to that extent, because you wouldn't be complaining if you'd gotten a better deal. But I think you have to take a step back and ask, before you even get there, was the advice that he was given to decline the plea offer, was that unreasonable? Was that unprofessional? Was that so far outside the norm that you can say Mr. Bennett was ineffective? And I think on this record, Mr. Bennett's advice to Mr. Hartman was reasonable, given the circumstances that, as he understood them, and as he was able to develop at trial, there were a lot of factors where one could make a reasonable address to the jury about a self-defense scenario.
Well,
And I think that given that,
prejudice measure under the Lafler line of cases, not that the person ultimately got more time, but that they would have accepted the plea bargain had counsel not acted in an ineffective way.
well,
And I think there is a difference there.
yeah, that Laffer standard is interesting. If you read that, I think all these cases would almost result in, I mean, if you're going to assume a court is going to accept a plea and it would have resulted in a lower sentence, I think if that's the construct we're using, I think a lot of these cases on the prejudice angle would be a open and shut case. I agree. And that's why I think I have to take a step back and say, was Mr. Bennett reasonable in advising that? I think, Mr. Hartman can arguably establish prejudice there because he got more, but I don't think it can be said that in the moment, Mr. Bennett was not giving professional, good, sound advice. And they do say that you have to look at these cases from the perspective of the defense attorney in the moment, much like a police officer on the scene of a crime makes a decision in the moment. Mr. Bennett, given what he had to work with and knowing what he could elicit and what he had to work with, it was reasonable for him to say that we have a good chance of beating this, Mr. Hartman, and I think you ought to decline the offer. And ultimately, that's what Mr. Hartman's affidavit reflects he decided to do as well. He decided to trust Mr. Bennett.
It's not ineffective to merely guess wrong. I mean, that's not what this kind of claim is getting at, because the decision to take a plea or not is always guesswork. It always involves trying to predict the future. And
Right.
and we don't know. No one knows. No one can see into the future to know what would happen at a trial.
Very true. I think if this had been a different case where there was just terrible circumstances that nobody could work with, I think it might have been ineffective to advise a man to take a plea under that circumstance. But I think Mr. Bennett knew Mr. Hartman had something to work with here. It was a reasonable advice. It was a reasonable strategy to pursue. And again, I don't think you get past the initial problem. There's no ineffective assistance here. That's
Unless
all
there's
I have.
any other
unless the court has
questions.
any
All right, thank you.
questions. All right, thank you.
I think, to your point, Judge Kinsley, whether or not guessing wrong is ineffective, I think you have to look at the information that they have and whether or not telling a client, if you believe Mr. Hardman, that they're going to win, is not really guessing. It's promising an outcome.
What about the threat to withdraw if he took the plea? How does that weigh into the calculus?
I would say that weighs heavily in the calculus. Going to withdraw if you plead to this, I mean, as he has, I mean, I think that gives some credibility to his right to testify. You know, I'm the lawyer, I'm going to make all these decisions, you're going to listen to me, if you don't listen to me, I'm going to withdraw. I mean, I think that gives more credibility to what Mr. Hardman argued than anything else, just because there's no valid basis to withdraw if you take the plea. The client has an absolute right to do things that may or may not be in their best interest. So I'm not sure if he would have a valid basis for that, but certainly that is coercion in terms of not taking the plea. There's obviously coercion, not in this case necessarily on people to take the plea, but here it's the opposite of not taking. I have nothing further. If you have no other questions, I appreciate your time.
Thank you. Thank you both for your arguments this morning. We will take the matter under submitted, issue a timely decision. Wish you both a wonderful afternoon. Jones and Conley versus Durrani. Good morning. Attorney Williamson, you can approach the podium when you're ready. Good morning.
Good morning, Your Honor.
Would you like to reserve time?
I'd like to reserve 4 minutes, if I may.
Okay. You can start when you're ready.
May it please the court, Philip Williamson on behalf of appellant Dr. Durrani and Cast. 2 years ago, or roughly 2 years ago, we were here on a petition for writ of mandamus and prohibition, asking the court to vacate essentially the underlying group trial order in this case. The court denied that petition, but made two important observations. The first is that there were some serious concerns with the group trial order, and second, that these are the sorts of problems that could be remedied in the ordinary course of an appeal. We come to you now in the ordinary course of appeal. Among the court's findings, or at least suggestions to the trial court, were number one and most important, that Civil Rule 42 governs consolidation for trial. Second, that findings.
This was not a consolidation, is that correct? Wasn't,
So
they
you're
were
on the-
tried together, but they weren't consolidated.
Well, they were consolidated for trial, which is itself an order that is governed by Civil Rule 42, which talks about consolidating cases at various points of the proceedings.
Right, you can either consolidate, I understood that this was joined for the hearing, not, the actions were not consolidated. Maybe we're just splitting on, maybe we're saying the same thing different ways. Because you're right, 42 governs consolidation, but consolidation of the actions, but also joined it for the hearing. It's my understanding that this was joined, but not consolidated.
Well, Your Honor, what you had were two disparate medical malpractice plaintiffs tried together in front of a single judge and jury.
You can go on, it's really inconsequential to your argument to a certain extent.
And in order to do that, in order to put these actions together for joint trial, the trial court must make a finding that the cases have a common question of law or fact.
Counsel, what exactly is the status of the record in this case as to these two parties before the trial started?
Prior to the start of trial, you had the plaintiff's motion for a group trial, or to set group trials.
And that's in Densler.
That's in Densler. You have Dr. Durrani's memorandum in opposition, obviously the reply, and then the court's order granting the motion for group trials. In that order, the court then directs plaintiffs to propose trial groupings. And then the court, and I think the court made a mention of this in the mandamus order, the trial court essentially says, I'm going to defer to the calendar the plaintiffs put in front of me. So you get a series of trial calendar orders. I think we're in the teens, at least at this point, of the court setting a calendar of consolidated trials, and each and every one of those calendar orders includes at the bottom a notation, defendants maintain their objection to group trials.
What exactly was put forward as to what Jones and Conley had in common? And what exactly did the trial court find as to what Jones and Conley had in common before the case went forward?
Nothing and nothing, Your Honor.
Well, something was put forward, right, of what they were, I mean, the plaintiffs had to have said something, right, of what was in common?
As a legal matter, yes, Your Honor, plaintiffs should have said something, and they did not. I mean, in fact, that is in part the reason for the mandamus petition. It's the reason why we're here on appeal, that plaintiffs never substantiated the Rule 42 requirements for consolidating actions for trial. I mean, you do not find the trial court making findings that these cases have any common questions of law and fact. And in his reply brief to the mandamus petition, Judge Reese himself told the court he did not engage in the Rule 42 analysis.
Why did they pick these two? I mean, they put together the proposed schedule, and they proposed to have these two be together. Why?
Your Honor, it's a question I would love an answer to. It's something it would have been great to have had a chance to fight about. But again, the trial court directed plaintiffs to prepare the calendar and indicated that he was going to defer to the calendar given to him by plaintiffs. And so, again, you have a record that simply doesn't contain the findings that you are supposed to have before you consolidate actions for trial.
So I just want to make sure I understand. I've read the Densler order. It's very, it directs plaintiffs' counsel to put together a schedule. I'm paraphrasing. And it says that he's supposed to comply with 42. And then the plaintiffs put a list together, and then the trial happens, and there's literally nothing else.
Correct, Your Honor. You do not have
Now,
the Rule 42
counsel, at that
findings.
time, the complaints had been filed, had they not?
I'm sorry, Your Honor?
The complaints on all of these actions would have been filed at that juncture. Is that
Correct,
correct?
Your Honor.
Okay. So would it have been error for the court to have relied on the complaints?
Well, we think it would have been error because the complaints would not have revealed a common question of law or fact, but you would have had a structural problem in that the court does actually have to find and identify the commonalities that would justify putting these two cases together for trial, in part because it gives the parties something to argue about. The plaintiffs actually have to come forward with that, and you just don't have that here. And in fact, you have no indication in the record that the trial court relied on the complaints to consolidate these
And
cases.
so do we really have more of a procedural problem under Rule 42 rather than a substantive problem in that the trial court just simply did not engage with any of the steps of Rule 42?
Well, Your Honor, I think the nature of Rule 42 is that it's both, but I think the easier problem to solve here is the procedural one. Rule 42 governs consolidation. There are steps you have to take. There are hoops you have to jump through under Rule 42. And if you don't jump through those hoops, consolidation is improper.
I want
Now,
to
the
go
reason
back
is
to the
substantive.
record. I want to go back to the record itself. Because as we've all discussed here, we all understand, this really is within the Densler case, right? Okay.
Correct, Your Honor.
However, before us, we have the record of the Jones and the Conley case, right?
You do.
Okay, so there was an opportunity to bring in other records. Has the Densler case record been brought into this appeal before us?
So the Densler record, as far as I know, has not been brought into this case. What you have is.
Have
oh,
you requested for this case to be supplemented with that record?
No, Your Honor. What you have in the, as the court is familiar with, a fairly large body of litigation here, is the trial court will often hold sort of global hearings to address certain issues that are going to apply to all cases. Things like, are we going to hold group trials? How are we going to schedule the trials that we've decided are going to go forward? And the court does not typically file the transcripts of those hearings or assign a case number to those hearings sort of at the beginning of the hearing. In fact, if you look at the,
But you were given an opportunity to supplement, were you not?
well, Your Honor, what we had asked for was to supplement the record with that 8-page scheduling transcript that had been omitted from the trial transcript for this case. But here, Your Honors, the court can take notice of decisions on the record that were effectively just filed under the Densler case number, but that clearly impact and implicate these cases. But Your Honor, I point out, I think we have in our reply brief, if the court's position is the only things we can consider are the transcript of docket entries that are under the Jones case number, the outcome will be the same. Those entries will show you a consolidation for trial, the utter absence of Rule 42 findings, and what we think is a trial calendar replete with, or a trial replete with prejudice. But at no point, even if the court looks at only the Jones and Connolly case numbers, the court will not find that the trial court or plaintiffs checked any of the boxes required for consolidation under Rule 42.
But
Is
that
this-
took place in Densler. This is what makes it sort of interesting.
Well, so, Your Honor, if you look at the group trial hearing transcript that we filed in the mandamus petition, you will notice at the very beginning of that hearing, the trial court says he's not even going to assign a case number to that hearing. It's sort of only weeks later that we get that nominally assigned to the Densler case. But as I said, that's sort of one of the recurring themes of this litigation, is that you will have the trial court holding hearings on any of a number of global issues or global questions that either don't initially get a case number or get sort of assigned a nominal case number almost at random.
Can you address the Ciuta case? I know your opponent will likely talk about it. It seems on all fours, so can you talk about how it applies here, how we should review it?
Yes, Your Honor, there are a number of problems with the Ciuta case, and it's not on all fours quite the way that that counsel might represent. So one issue you have is, assuming you believe Ciuta is correctly decided, we don't. What you have in that case are cataract surgeries. Cataract is a condition, and there's sort of not a lot of different ways you can have cataract. You have them or you don't. It's not even really like nearsightedness, where you might have a range of near or farsighted issues. You have cataracts or you don't have cataracts. They're treated the exact same way. You don't really need to make the kinds of individualized differential diagnoses that you would have had in Dr. Durrani's case. These are all things that we pointed out to the trial court. And so it's an easier case to say 7 people, identical condition, identical course of treatment, identical sets of errors, sets of mistakes by the physician. Perhaps you can put those plaintiffs together. You don't have that here because there's really nothing you can say Mr. Conley and Ms. Jones have in common that would have been satisfied by a common evidentiary presentation in the trial here. We also believe, Your Honor, Ciuta is simply wrong. The court's justification for consolidation there were the same defendant, which is not a grounds for consolidation. Otherwise, you'd have every slip and fall case in the country against Kroger being filed for a joint trial here in Hamilton County, and we don't see that. That the case involved the same legal theory, which again is not a common question of law or fact, and that it included some of the same witnesses. But a witness is not a question of law, and a witness is not a question of fact. A witness might testify to facts, but those are not the same thing. And so you, in fact, don't have the proper Rule 42 findings in SIUTA anyway.
So are you saying that the fact that it's the same for claims on all of these cases, that is not a common question of law? And if so, then explain.
Sure, Your Honor. An overlapping legal theory happens all the time. These are all torts. There is a limited universe of the types of tort claims you can bring. But that is not a question of law for which there is one answer, common presentation of a single answer that will answer that question for all cases at the same time. So a great example is the multi-year fight we had over the statute of repose. The statute of repose reads a particular way or it doesn't. That's a singular question that you only have to answer once that will answer that legal question for all of the cases. Whether Dr. Durrani committed negligence or committed malpractice against Mr. Conley will tell you absolutely nothing about whether he committed malpractice against Ms. Jones.
Could you ever join malpractice cases then?
I can stand here and concede that it's possible,
Okay.
though I can't think of what those circumstances would be, because medical malpractice actions are sort of particularly unique to each plaintiff. Something, again, this court pointed out in its mandamus order, that
What about a situation where a surgeon was performing the same defective technique over and over and over again, and that technique was known to be invalid in the medical community? The injuries wouldn't necessarily vary from person to person. That's not what we have here, right?
Correct, Your Honor. That's not what we have here. You have, I think, very importantly, plaintiffs with very different medical histories. You have a different set of inputs and a different set of injuries to be treated. Depending on who you ask, you have radically different sets of outcomes. You even have, in these two cases, different post-surgical courses of treatment and courses of injury. So in this case, Ms. Jones complains of a number of injuries and debilitations following surgery that it turns out are traced to some injuries she suffered well after she was off the operating table with Dr. Durrani. If you look through the trial transcript, if you look even through the complaint in these cases, there's nothing about these two cases where you could say there is a question for which a common presentation of either law or fact is going to answer this question for both cases at once.
Were both of these cases, the theory was that Dr. Durrani recommended surgery when surgery wasn't necessary?
That is part of the theory of both of these cases.
Isn't that kind of something that can join these cases? He's performing surgery on people who didn't need it.
Well, Your Honor, again, not a common question of law or fact that could be answered with a common presentation as to both cases. There is no piece of evidence that you could point to and say, yes, this evidentiary presentation answers for both plaintiffs at once that Dr. Durrani performed an unnecessary surgery on that plaintiff.
Wasn't part of the battle of the experts the issue of whether this additional analysis, this flexion extension analysis, should have been performed?
Your Honor,
In other words, whether based on the analysis that was done, whether that was sufficient to justify or whether there was further action that should have been done.
so you can have a case where the argument of like what kind of malpractice occurred here is going to be, you will advance the same theory about what the doctor did wrong. That does not turn it into a common question of law or fact, where a single presentation of evidence is going to answer that question for both plaintiffs. There's a fair argument that maybe you have to perform this particular analysis as to one plaintiff, but not necessarily as to the other, or that the failure to perform that analysis injured one plaintiff and didn't injure the other. But there is no situation where you would say, well, He did the same thing wrong in both of these cases, and thus we can answer with one common evidentiary presentation that malpractice occurred here.
Well, wasn't that in essence what happened with the presentation from the experts?
Well, again, Your Honor, we will concede that these being medical malpractice tort cases, it's a limited universe of things you could allege have gone wrong. That does not mean that the same evidence will answer the question for every plaintiff, for both plaintiffs, or as you're going to see in the next year, all three plaintiffs at once. This is not like, for example, the Tyson versus Bofeco case, where the Supreme Court is outlining what we mean by a common question of law or fact, where you have a number of poultry workers subjected to the exact same sort of punch-in, punch-out requirements, or the same
If there's any
safety
other
equipment.
questions from the panel, because we're really well past your time. All right, thank you.
Thank you, Your Honors.
Good morning.
May it please the Court, Alan Stavman, on behalf of the plaintiffs. I'm here and will be here for all of the Durrani appeals moving forward, because one of the things that I witnessed in watching some of the arguments that I was not involved in is regular misstatements of the facts because appellate counsel is not present at the underlying proceedings. And here, they did not file any transcripts related to the arguments and statements that were made by the judge, what his findings were, what the discussions were, and what the answers to the kinds of questions you're asking. He starts most trials by asking a series of questions about, are the lawyers the same? Are the parties the same? Are the doctors the same? Are all the expert witnesses the same? And in this particular case, what counsel didn't tell you while he directed the plaintiffs to draw up the initial list, the list that was finalized went forward by agreement. The defense had an opportunity to say, no, we don't want this one, this one, this one, and the judge conceded and accepted some defense cases and not all, some plaintiffs' cases but not all. Yes, the overwhelming choices were plaintiffs' cases because plaintiff brought the cases. These two cases both not only involved
So
unnecessary
are you
surgery.
saying that even what was agreed upon is not what the judge actually ordered in these jointers? Is that what you're saying? Did I misunderstand?
No,
what you
no,
said?
no. What was agreed upon is what was
It
ordered.
was exactly what was ordered.
So they say plaintiff picks, but then there was a process. Defendant objected and said, we want a couple of these sprinkled in there. And then there was an agreement, and the judge put on the record that these cases are proceeding by agreement as it relates to the consolidated cases and how they will proceed. These two cases that are before you today are not only malpractice cases, they're not only spine cases, they are lumbar spine cases. They involve the same area of the spine, the same type of diagnoses, the same expert witnesses, the same allegations, negligence, fraud in the inducement, informed consent, battery, medical malpractice, the negligence. And the experts were the same on both sides for both cases, and the testimony related to was the radiology exaggerated, fabricated, stretched, and was it used as a common practice of Dr. Durrani in convincing these people to go to surgery? Now, when you look at SWEDA, it's the same thing. Everybody recovers a different way from the same surgery. So to have Dr. Durrani's lawyer stand up and say, well, SWEDA, everything was exactly the same. No, it's not. Everybody has a different reaction. Everybody has a different mental state to going into the surgery. Everyone has different fears, trepidations, and everybody recovers at a different rate. and some don't recover at all.
Counsel, can we rewind? So I heard a few things that were new, and I want to make sure I know where they are in the record. So first you said that the list was kind of cold between the parties and that it was agreed upon. Where can we find that in the record?
It's referenced specifically in our brief.
Okay.
I don't remember the exact site off the top of my head.
Okay.
But it is in the first portion where we are supplementing and correcting the procedural posture that they put forward.
Okay.
So it's discussed there.
So
But
there
what-
will be a transcript somewhere in our record in this case that will reflect this kind of back and forth process.
There will be information based upon the reference. This brief was written by Bob Winter.
Okay.
And when I went over it, I saw the reference, I saw a citation, it goes back.
All right.
And he purposely brought it forward as the alternate or supplement to the procedural posture that was put on by appellants.
All right,
Now,
fair enough.
the-
And then you also said that the judge starts the case by asking, are the lawyers the same, are the parties the same, you know, what is the similarity in essence? Where will we find that?
That is something that he does in cases in general. I don't know if it's in this specific case, because my recollection is they didn't provide all the transcripts. And that's part of their problem. Things they are relying upon and saying to you are not necessarily accurate. When you ask the question, where would we find this commonality issues? Well, you can't find it without a transcript. But you know what their answer was? Nothing and nothing, which is the double talk that occurs. Nothing and nothing. That's not true.
You can expand the record, right? So if there's something that you know of that occurs that isn't in the record that they submitted, you can add to the record, right?
Well, except that it's the appellant's burden to file the transcript, not the defense, not the appellees. And they went forward with an appeal without a transcript. That was their risk. I'm not here to correct their problems in not providing the court the necessary information for them to prevail. They can't come before you and say, nothing happened, when nothing happened because they didn't provide you with the transcript.
Well, how are we to know? I
Well,
mean,
that's the
there-
point, is
There's
that-
a record that's devoid of information that the rule prescribes as being necessary.
Except it's their appeal, and that's how the appeals get dismissed procedurally for failing to provide the court with the necessary record to be able to prevail as an
But
appellant.
how do we know a negative? Maybe I'm missing something. But, and let me just get through this because I really want to make sure I
No,
understand.
sure, I'm not rushing you.
So, Rule 42 requires some kind of inquiry into commonality. And I hear your position is that there was that, but that they didn't have it typed up to give to us. And now they're saying, because they didn't type it up to give to us, that it didn't happen.
No, they're saying that there was no transcript of interest to present when there was transcripts of various discussions about commonality and issues. It's their appeal, and it's for them to show you that 42 wasn't complied with. When you talk about proving the negative, it's not for me to come forward. The burden doesn't shift to me because they say in a vacuum with no transcript that this rule wasn't complied with. You can look at the complaints and see the commonality. You can look at other pleadings in the record and see the commonality.
But do we know if the trial court actually did that?
That's for them to show you whether they did or they didn't.
But if they didn't, then it wouldn't be there, right? And
Well, that would be for
That's
them.
what they're
But see,
saying.
that's how you prove a negative. You present the transcript and say, look, Your Honors, Judge Reese made no analysis.
isn't that what they're saying?
No, because they didn't present the transcript to you. They can't tell you what's in a transcript that they haven't made an official part of the record. That's part of the problem I have with their entire brief.
As I understand it, there isn't, and everyone's in agreement that everything that took place with regard to Rule 42 took place in Dinsler. Am I understanding that correctly?
Well, it took place in Densler and takes place regularly.
But, no, I'm going to rephrase that. That
Yeah, I think
with
that
regard
that's-
to this case,
The initial,
any presentation, any arguments, any
Right.
whatever, that it's in the Dinsler record.
and
I
in
don't
that.
think that's at issue here, right?
And in that
So-
record.
And that Dinsler record is not part of our
Right.
record.
And-
And what you're saying is that your opponent is making arguments relying on the Dinsler record and yet failed to make that part of a
Correct.
record. Am I understanding that
Yes,
correctly?
because I'll stand here and tell you my impression of what happened during that hearing, which is we had a full discussion of every one of these issues, and that we've been talking about consolidation for years. It's not appropriate for me to do that. It's not part of the record.
But nothing was put on the record in this particular case regarding these two
That's
cases.
not true.
Okay.
There's no record to tell you that.
There's
my
no record to
recollection-
tell us that nothing was put on the record?
My recollection is that every time we had a discussion of consolidation, all of these issues were regularly talked about.
In these cases, not in the other case?
In general, I don't have the transcript for this.
Because I can understand having a hearing in another case and saying, okay, this is going to pertain to all these other cases, but then when you get, in this particular case, you'd want to get something on the record for that.
But they're the ones that say it didn't happen, but they don't show you it didn't happen. There's ample evidence you can look at.
So
That
the
it happened.
pleadings. You
So
can-
just for clarity, everything regarding Rule 42 happened before the record of proceedings that we have before us?
My belief is yes,
Okay.
and is ongoing every time we start a trial. And what's interesting in this case is trial counsel, after they made their initial objection in the group trials, they make an initial objection at the start of every trial to group trials, but then they do not bring it up on directed verdict, and they do not bring it up in their motion for new trial, and they proceed with a consolidated trial that they participated in picking.
Now, let me ask you another question. Rule 42, does it require for a party to move for a joint or a consolidation under Rule 42, or can it be sua sponte?
Well, the joinder was asked for years ago, going all the way back to Judge Schweikert, for the entire
But as a matter
plaintiff.
of law, does it require for the parties to move for such, or can it be done sua sponte?
Well, the problem, that what I'm having with the question is I believe that it is discussed as a motion before each trial, that it's going to be consolidated, the other side objects. But I think that the judge can look at it and say, I plan on consolidating all of these cases, as other judges that we had during the litigation that were one-off judges before they were consolidated were surprised that they weren't moving forward in groups, and then far bigger groups than we actually had. But again, that's not before you. So I can tell you all kinds of things that have occurred over 100 jury trials, well, actually more than 100 jury trials that I've participated in. And I can tell you it's not prejudicial. In this case, proves it, because one of the plaintiffs was found to have permanent injury. The other plaintiff was found not to have permanent injury on the facts. Okay? And the defendants win from time to time. Do they win in the same rate they win in one-off trials with someone that isn't Dr. Durrani? No. But I believe that I've won somewhere about 81 or 2% of the cases. Mr. Volman, I think he's sitting back there, has told me, no, I only win about half the time. Well, that in and of itself shows you that the consolidated trials aren't prejudicial if they're winning between 15% and 50% of the time. In addition, in the federal court, all the cases were consolidated. We tried 6 together. We've tried 2 and 3 together. It's not uncommon, and the juries are able to sort it out. The judge specifically has a conversation with at the end of every trial. Were you able to keep these cases separate? Were you confused at all? They give them notebooks. They take notes. The notebooks have separations for each trial. We get mixed results sometimes. Sometimes somebody gets a really big verdict, somebody gets a very small verdict. because the juries are listening to the evidence as it relates. But this idea of common law and fact, where we're going to get down, if we believe the argument that was just made, that if the plaintiff in each case doesn't use the same exact words, well, that's not a common issue of law, of fact.
Well, it
No.
sounds like you can, based on their argument, you can never consolidate medical malpractice claims
But that's not true.
or cases.
Your court, this court, consolidated SWEDA. And they tell you, well, you can't look at who the lawyers are. You can't look at judicial economy. That's not part of 42. That's exactly what this court did. It's right in the decision. It's quoted in the brief. All of the cases contain the same defendants, set forth the same legal theories, and would call upon similar testimony. It doesn't say exactly the same. It says because common issues of law in fact existed, judicial economy was served by the consolidation. Moreover, given the verdicts, there's no evidence of confusion by the jury. The jury was clearly able to handle the voluminous evidence and to resolve the cases individually. That's 7 cases. We have 2. And given the fact the verdicts are different based upon similar facts, but how the jury applied those facts to each, they were clearly not confused. And your decision says similar. It doesn't say exactly the same. Everything must be exactly the same. That's just not true. And as a matter of fact, these lawyers, maybe a different set, back in 2015 or 16, consented to class action status in the federal court. And then because of some other things that occurred in terms of how the parties wanted to move forward, the case got decertified. So people will tell you that class actions can never proceed in a medical malpractice setting. Not true. They once agreed to it, and there have been other medical malpractice classes. But see, these are consolidated. They have, first of all, we could just take the point of view that they're all spine surgeries. And the overwhelming majority, the super majority of them, involves degenerative disc disease, bulging or ruptured discs, radiculopathy caused by disc pressure on the nerves. That's the overall general theme until you get into a couple weird nuances like Ehlers-Danlos syndrome, which is hypermobility, and a few others. But the general theme of all Dr. Durrani's cases is overstatement of the radiology, spine surgery, evidence from him of bulging or ruptured discs that are pressing on nerves, causing radiculopathy, and if the patients don't go to an immediate surgery, their heads will fall off, they will be paralyzed, they will be in a wheelchair.
Counsel, I can completely appreciate the efficiency objective of these combined trials. Can you just briefly direct me to the common question of law or fact, because that's the Rule 42 standard?
Whether he committed negligence, whether that negligence was the proximate cause of these parties' injuries. Was the negligence that he committed based upon a breach of the standard of care applicable to same or similar orthopedic surgeons operating on a nationwide basis? As a result of the proximate cause, what is the amount of economic damages and what are the amount of non-economic damages? What are the amounts of medical bills? Did he offer them full and complete informed consent? The forms are all identical. Question.
And how is that different from a driver who drives negligently and hits car A on one day and drives negligently and hits car B on a second day?
I don't know that you can compare the two because I don't know that those two plaintiffs will ever become acquainted in a way to compare all of the facts and circumstances, make a decision, and come forward with a motion to consolidate. So some hypotheticals, they're not able to be answered because we do have a circumstance where there are 550 plaintiffs, and we are able, because of the large body of plaintiffs, to look at a real statistical sample and make a determination as to whether there are common issues of law and fact. And you can look at the complaints that are part of the record, and they all have the same exact causes of action. What's interesting is if you go to the evidence, Dr. Durrani does this thing where he puts in a letter to the primary care physician. These are my findings and my recommendations. And it's his impressions and diagnoses. The lists are virtually identical for every plaintiff. Spondylolisthesis, retrolisthesis, bulging disc or ruptured disc, radiculopathy, left, right, or bilaterally, neurogenic claudication. These are all his findings for every patient. Every single patient has this list of 5 to 8 things that are absolutely identical in every one of his findings, whether it's cervical, thoracic, or lumbar. Now, thoracic's much less likely with Dr. Durrani because the ribs give you added support to your thoracic spine. So there are very few thoracic surgeries. They're overwhelmingly lumbar, and then they're cervical. And some people end up with cervical and lumbar surgery and multiple surgeries. So there is a list from Dr. Durrani's own mouth laying out the common facts, the common diagnoses, and the common treatment. These are either what are called simple decompressions, or they are instrumented fusions from different procedures, depending on which level it is. Sometimes they go in from the side, sometimes the back, sometimes from the front. But they're instrumented fusions, or they are
So unless there's any other
decompressions.
questions from the panel. All right, thank you.
Okay. Thank you. I appreciate that these were consolidated for this hearing. My wife was impressed that I went through this whole book getting ready, and I said, no, this whole section here I didn't need to do. Thank you.
Your Honors, a few things to cover, so I'm going to try to move quickly. The first is plaintiff's suggestion that these cases proceeded by the agreement of defense counsel. It's simply not true, and you need to look no further than the calendar setting these two cases for trial to find defendants maintain their objection to group trials. All that defendants agreed to was this particular week in June is a day that we can go to trial. If you take plaintiff's argument, basically the only way to have maintained an effective objection to group trials would have been to simply not show up and accept a default judgment. And I don't know that the rules require us to do that. Your plaintiff's argument would tell you that plaintiffs will be able to manufacture commonality in virtually any case. And I don't just mean the medical malpractice actions in front of you here. If calling the same expert and suing the same defendant is enough to get you through the Rule 42 gate, any two plaintiffs are going to be able to summon a similar expert. Any two plaintiffs are going to be able to advance the theory the defendant committed negligence in a way that harmed me. But that's not what Rule 42 asks
How
for.
would you there was an argument about class actions. How would you differentiate this from that?
Well, so class actions have a similar commonality requirement. And the U.S. Supreme Court has been absolutely clear on what that means. It means that a common presentation of evidence is going to answer a particular question for all cases at once. Your Fair Labor Standards Act overtime pay case is a classic example of how this would work. You're either in the category of workers who are entitled to overtime pay or you're not. You see this in toxic tort class actions, where the common question is, well, is that substance that got spilled in our well water carcinogenic or not? Is it going to injure a person, or is it inert. That's a common question for which a single presentation of evidence is going to answer the question for all plaintiffs at once. You don't have that here. There's no point where you could have said, even because Dr. Durrani's performance of surgery on Mr. Conley was deficient, his performance of surgery on Ms. Jones was also deficient. One of the reasons we know this is that this court said so in Stevenson and in Mann when we were fighting about the Durrani collage. The court pointed out that simply mentioning that there were other medical malpractice actions against Dr. Durrani was an evidentiary error, an abuse of discretion, and in those cases, at least in Stevenson coupled with other errors, was sufficient to reverse the judgment.
And understood, I understood your point there. I guess I'm still would like your position with regard to, in this case, we have the same pre-op analysis performed by Dr. Durrani and the determination of the necessity based on those evaluations. And they were, the experts on each side were quite clear. One side was saying, hey, that wasn't sufficient, there should have been more, and surgery being recommended was the breach of the standard of care. The other side saying, yeah, that was sufficient, and there wasn't a breach with the determination based on those analyses. How is that not a common issue of fact or law?
They are asking the same question. They are advancing the same legal theory, but that's not what Rule 42 asked for. Common question of law or fact is one where the same evidence or the same legal answer is going to resolve the question for both cases at once.
How is it that doesn't resolve it for both? When it's the same,
So
and it's
all-
the same surgery that was performed on both?
What you have is an expert saying, Mr. Connolly underwent surgery, Ms. Jones underwent surgery, and in both cases, those surgeries were medically unnecessary. But-
With the same pre-op analysis and the experts saying there should have been an additional analysis that should have taken place before the determination.
So the fact that, and I think Judge Kinsley got at this with the car accident example, the fact that you think the defendant did the same thing wrong in both cases doesn't actually tell you that you have a common presentation of evidence that's going to answer that question.
Unfortunately, in criminal cases, they do join those kinds of things quite often, so.
For which there is a different set of
There's a different,
joinder rules.
exactly, there's a different jointer rule.
With, Your Honor, prejudice assumed. But what plaintiffs have brought to you, again, as I think we've pointed out in our briefs, it would mean every slip and fall case against Kroger could be joined for a single trial, because those plaintiffs would all come to you with the following presentation. There was water on the floor, maybe in the produce section, maybe there'd been a spill in the canned beans.
I understand.
Kroger was the defendant.
I understand,
slipped and I
I
hurt
really
myself.
understand where you're coming from, I really do. In that situation, there wouldn't be the battle of the experts on the same facts, on the same surgery, and so on.
Well, Your Honor, again, the fact that they've called the same expert who is going to say defendant committed medical malpractice in both cases is not a common question of law or fact. The shared witness and a shared theory are not common questions of law or fact. It is
Counsel,
not.
I don't want to put words into your mouth, but what I'm hearing you argue is that really the common question standard is a common answer standard, and that in order to meet Rule 42, there has to be a common answer to the question across all cases. Is that the right way of looking at Rule 42?
I think that is mostly right. It is that a common presentation of, it's not that the answer has to come out the same, but that a common presentation of an item of evidence or a legal answer is going to resolve the question for both cases or for all cases. For example, the common question of whether secondhand smoke can in fact cause lung cancer. That's a common question that our good friends in the state of Florida spend a lot of time resolving in common for a class of plaintiffs about whether a particular item can cause birth defects. That would be a common question of fact that can be answered with a single presentation that doesn't actually turn on the particular facts or particular history of any given
And
plaintiff.
is it your position that when we necessarily have variation in the answer, that we don't have a common question?
Yes, but also when you have variation in the kinds of proof or the type of proof, or when, again, you could not bring in an expert physician into the room to say, yes, in every single case, product X is going to cause cancer, or product X is capable of causing cancer. You're going to lack that common question of law or fact.
So
Put another way.
So basically, it sounds, from my previous question, if we agree with you, most medical malpractice cases are not going to be able to be joined because they're going to be different.
That is correct, Your Honor. Most medical malpractice actions are not going to be joined. You don't see a lot of joined medical malpractice actions. And to ensure the court is not sort of concerned about that being a serious problem, that's a point this court made just last year, that in fact, consolidation of medical malpractice actions is going to be rare because they tend to be unique enough that trying to mix evidence, mix presentations is going to be a fraught problem. Your Honor, if I may, two quick things to
If you can do
clean
it
up.
in 30 seconds.
Absolutely, Your Honor. The first is that you heard a lot from opposing counsel about things that happen generally in cases in the absence of a record site. You have the entire trial transcript of Jones and Connolly here. You will not find the sorts of things that plaintiff's counsel has referred to in these cases. The other is you heard repeatedly, well, there's a list of 5 to 8 things that might be identical in each case, or you have, Dr. Durrani performs this surgery or that surgery, which just reinforces these are not identical cases, these are not overlapping cases, these are not common questions of law or fact. Put another way, you will not hear from plaintiffs and you will not see in the record an answer to the question, what do Mr. Connolly and Ms. Jones have in common other than Dr. Durrani and the choice of experts and the lawyers? And if there's no answer to that question, these cases cannot be consolidated for trial. For these reasons, Your Honors, we respectfully ask you to vacate the judgments below and remand for new trials, plural.
Thank you. Thank you.
Just 15 seconds.
But thank you. Thank you. Thank you both for your arguments this morning. We'll take the matter into submission and issue a timely decision. Thank you.
Do I need to move to the other desks?
Sure. All righty, so now we're going to hit our arguments on Anderson v. Durrani. Good morning. Whenever you're ready.
I'd just like to split my time in half. This
Okay.
isn't going to take very long. The second half of our briefing are issues that have been before the court before. We're preserving those and still asking the court
So
to...
just to make it easy on the timekeeper, how about if we do 8 and 7?
That's fine.
Okay, all right. So we'll reserve 7.
Okay.
All right.
What I want to just address, and it's really not a long argument, is this issue of vicarious liability. So vicarious liability is not a medical claim. And we don't have to get into that whole argument. And vicarious liability historically runs with the statutes that apply to the employee. There isn't an independent vicarious liability statute of limitations that is different than the one that runs with the employee. And what's interesting when you look at the cases that we've cited, and you look at their briefs saying, well, they don't cite a case that says what they want it to say. The cases they cite don't say what they want it to say. And what I mean by that is we have converse here. So if you read those cases say, well, the doctor was out on the statute of limitations or the statute of repose. And therefore, you can't have a freestanding vicarious liability because the statutes rise and fall with the employee. In this particular case, the employee doesn't have a statute of limitations, nor do they have a statute of repose that has run. And so our argument is simply, when you look at the cases that do exist, logic would indicate that the converse of those cases would apply. So that since Dr. Durrani both has a statute of limitations that hasn't run and has a statute of repose based upon the Elliott decision that hasn't run, then in these children's hospital cases, assuming that, and most of these, if not all, were minors, so they were getting the benefit of minority, and then they get the benefit at the time from when they turn 18, and then you look at all that, because by the time they turn 18.
Counsel, this isn't briefed, and I apologize for just springing this question on you, but I'm just intellectually curious. How would you respond to the notion that a third party's liability and the ability to be sued after a certain time period rises or falls based on the actions of someone else? Does that raise any due process concerns for the third party?
But that is vicarious liability, that you're responsible for the negligence and other certain acts of your employees. And by employing that person,
Sure.
that is what occurs. And yes, if you employ someone that ends up in a situation where the statutes of limitations haven't run and the statute of repose hasn't run, well, unfortunately, that's just the luck of the draw. And as we argue in the brief, and we think that the record supports it because all we have are the oral arguments on the motions, that there were plenty of people at Children's Hospital that knew what Dr. Durrani was doing. This didn't come as a big surprise. And so...
Is there a way for them to cut off the statute of limitations somehow? I mean, you're arguing that Children's Hospital is essentially, in this case, subject to an indefinite statute of limitations by virtue of Dr. Durrani's behavior.
Yep.
Would there have been anything for them to do to cut that off?
There isn't a statute that says that they get that protection, nor is there a case that says that, because this isn't a medical claim, so they're not going to get the medical malpractice statute of limitations. This is vicarious liability, and all of it runs through the acts and timeframes related to the employee. So we can ask, in terms of what you're worried about, that maybe there should be an absolute cutoff. There could be a statute of repose passed by the legislature for vicarious liability. In no event will it be more than 10 years. But it's not there. And see, all of the cases deal with either the employee wasn't sued, or the employee has settled, or the employee's statute of limitations or statute of repose has run, and then the hospital or the medical practice moves to dismiss, and the court says, well, you can't have vicarious liability without an active claim against your employee, so you're out, you're safe.
And your argument is that you, and by you I mean the plaintiffs generally, didn't really know about Children's Hospital's alleged actions until the 2018 packet was delivered.
Right. And then I knew further when I took the deposition of Dr. Wall, where and I asked him, would you take Dr. Durrani back? And he said no, and I said, why? His personal habits and his surgical indications. And then we have the bizarre fact that's mentioned in here, that they allowed Dr. Durrani, after they parted ways in August of the year that they parted, to continue to do surgeries well into the next year, and helped him, even though they wanted him out, helped him establish his practice at Westchester Hospital. So there's ample things going on here that indicates this isn't a complete shock. This isn't somebody took the medical records and hid them, or they were doing surgeries. If, let's say, a surgical center closed at midnight and they were going in at 3 a.m. and doing experimental surgery, and the owners of the surgical center that had credentialed him and allowed him to go in there didn't know what he was doing. This was a 24-hour-a-day facility. Unlike the other Durrani cases, he is an employee. At Children's Hospital, you're not just credentialed, you actually get paid a salary from Children's Hospital. That's completely different than a doctor you see at Westchester Hospital or at University Hospital. They are just allowed to use that facility because they met the credentialing requirements. They are not paid by the hospital. That's why you get an individual bill from University Hospital and you get a bill from the medical practice. You do not, when you go to Children's Hospital, get a separate bill from a physician's practice. It's all because Dr. Durrani and the others are direct employees. And that's the whole concept of vicarious liability. He worked for the hospital. His full-time activities were at a hospital where he was a member of a department that had a hierarchy. They were all together there, operating as the pediatric orthopedic spine unit or the pediatric orthopedics, and they got a paycheck once a week or twice a month, whatever it was, from Children's Hospital. I know from others, they had a contract for their employment.
If you'd like to reserve your 7 minutes, okay? Thank you.
No, so that's my point, which is you need to have a rule for the converse, and we don't. Thank you.
Thank you.
Good morning. May it please the court, David Brittingham for the appellees. The 3 questions before you have been answered time and time and time again. And let me start with the question that was the only question that Mr. Statman chose to address, which is, and it's much narrower than he phrased it to you. The question is whether or not the medical statute proposed for medical, or the statute proposed for medical claims can in fact toll the claims for vicarious liability against Children's Hospital if they are told for Dr. Durrani. These are medical claims. A hospital in and of itself cannot be held negligent. You can't just bring a medical claim the hospital was negligent. A hospital can only be held liable for medical claims through the vicarious liability for the acts of its employees, its doctors. And this court in Elliott, and the Supreme Court affirmed it, has already answered the question here. And the answer to that question is, while the statute, the 4-year statute of repose may in fact toll for Dr. Durrani, while he's no longer in the jurisdiction, it does not toll for Dr. Durrani's employers or the hospitals where he performed surgery, including Children's Hospital in this case. That is the precedent from the First District. It was affirmed in total by the Supreme Court. They brought this, they tried to raise this very same argument, whether or not the 4-year statute of repose would apply to the hospitals or employers, to the Supreme Court, and the Supreme Court declined to hear it, accepting in total the decisions of this court, which said that while The 4-year statute of repose may have been told for Dr. Durrani. It is not told for the hospitals or employers of Dr. Durrani, including Children's Hospital here. And where those claims against the hospitals were not brought in a timely manner under the statute of repose, they're barred. The trial court properly relied on that precedent and dismissed those claims. To your point, Judge Kindley, the Supreme Court in Antune made it clear that the statute of repose is a real statute of repose. And they did that for just the point that you made, which if we don't give descendants some predetermined certainty with respect to what kind of liability they can expect in the future, they're going to be subject to the whim of an employee or a doctor who left the jurisdiction, went to another country, and is likely never to come back. And the purpose of the statute of repose is then gutted, because then those claims for vicarious liability are indefinitely told for reasons far beyond their control. That's the reason for the statute of repose. The trial court acknowledged and thoughtfully cited the precedent on that question. It's been squarely answered correctly, and that decision should be affirmed. The two other questions before you, Mr. Stabman didn't address them. I don't know if you'd like me to. Those questions have been raised and answered for a very, very long time in this district. Whether a negligent credentialing claim is a medical claim subject to the 4-year statute of repose, the law in this district, and as held by many other courts, is in fact that it is, and must be brought within 4 years or it is time barred. That is what happened here in all of our related cases. The trial court judge recognized that long line of precedent and correctly dismissed those claims. That should be affirmed. Finally, as the appellants acknowledge, I think Mr. Stabman acknowledged either verbally or by not addressing it, they certainly acknowledge it in their briefs. The third question is whether or not claims for fraud, including fraudulent concealment or misrepresentation, at least in the context of this Dr. Durrani litigation, are medical claims subject to the 4-year statute of repose. They are, as this and other courts have held time and time again. They have to be brought timely within the 4-year statute of repose. They were not. The trial judge correctly dismissed them, and those decisions should be affirmed.
Thank you.
Thank you.
The issue of vicarious liability is not a medical claim. It's undecided, because vicarious liability is the claim and medical negligence is the claim against the doctor. And the way vicarious liability is set up, and the case law is clear, and we cite numerous examples of it in the brief, primary liability rests with the employee who committed the wrong, and the secondary liability rests with the employer by reason of the relationship, not by reason of the wrong, by reason of the relationship. So I don't see how, given the state of the law relating to vicarious liability, you can say vicarious liability is a medical claim. It's not. It's pass-through liability because of the state of the relationship, not the facts and circumstances of the wrong. You don't get to say this is a medical claim or this is this type of claim or that type of claim. If it falls under the umbrella of vicarious liability as defined by the Supreme Court and falls under the umbrella of those things that are covered by vicarious liability, because certainly you can step outside the umbrella of vicarious liability. Some things aren't related to your employment at all. So an employee that rapes their next-door neighbor just because they're employed, that's not vicariously covered by vicarious liability. And that isn't, if it's a doctor that did it, it isn't a medical claim because the doctor did it. So you have to go with the actual analysis of what is vicarious liability. And it is not a medical claim. And yes, sometimes the risk is burdensome when you have employees. But the law's the law. And in this case, until someone either legislates or the Supreme Court decides, you know, we're in this position where I can tell you what I believe vicarious liability looks like, and that I believe, based upon the clear language of how they decide these things, primary and secondary liability. Primary liability are the acts, the secondary liability is the employment itself. And certainly employment is not a medical claim. So I don't see how the converse of the cases that say when the doctor's out, there is no claim for an employee act against an employer, the converse isn't true. Thank you.
Thank you. Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. And that concludes our hearings for today. Thank you very much.